Good day, sir. My name is LEONG, and we are from Group 16, which is LEONG, NAZIRA, and partners. And our group members consist of NISRINA, SYAZWANI, AINA, and NAZIRA. And we'll be presenting on our assignment. The first issue of the current case is whether the evidence of the death of one other widow and two young girls are relevant to be admitted in the court for the charged murder of Mrs. Tua. So at the outset, it is relevant to discuss Section 5 of the Evidence Act, which places great emphasis on the need for evidence tendered in court to be relevant. And relevant here means it is prima facie admissible. And what it means by prima facie admissible means that sometimes, even though the evidence is relevant to the current case, but it may not be admissible. Say for example, next slide, the similar facts evidence. Generally, the similar facts evidence is not admissible because it is prejudicial to the accused. And this was held by the Markin case, the landmark case of on the similar fact evidence. The court held that it is undoubtedly not competent for the prosecution to adduce evidence tending to show that the accused has been guilty of criminal acts other than those covered by the indictment, for the purpose of leading to the conclusion that the accused is a person likely from his criminal conduct or character to have committed the offense for which he is being tried. But the Markin case also provides an exception to that principle, and it is known as Markin second link principle. The court held that, on the other hand, the mere fact that the evidence adduced tends to show the commission of other crimes does not render it inadmissible if it be relevant to an issue before the jury, and it may be so relevant if it bears upon the question whether the acts alleged to constitute the crime charged in the indictment were designed or accidental, or to rebut the defense which would otherwise be open to the accused. And this has been recognized by the apex court in both Malaysian and in Singapore. And the court in the Singapore Court of Appeal in Tan Benji case held that, as to the former, it has been argued above that the rationale of the rule excluding similar fact evidence is so that every person charged with the offense may only be convicted upon being proved to have committed the act within the charge. It will be subverting established jurisprudence to allow a conviction based on the particular disposition of the accused, based on the contention that the accused is a type of person who would commit such an offense. On the other hand, there may be cases where the interest of justice clearly outweighs any prejudicial dangers inherent in the evidence. And similar fact evidence is also recognized in the Evidence Act, specifically Section 15. It states that when there is a question whether an act was an accidental or intentional or done with a particular knowledge or intention, the fact that the act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. And this wording of the Section 15 is identical with the Markin second link rule. And in illustration A of the Section 15, it provides that A is an accused of burning down his house in order to obtain money for which it is insured. And the fact that A lived in several houses successively, and each of which he insured, in each of which a fire occurred, and after each of which fires A received payment from a different insurance of office, are relevant as tending to show that the fire was not accidental one. And the key facts in the illustration here shows that no one else saw A burn the house. But through the past occurrence, we can identify that A is the one who burned the house, and the burning is done intentionally. And this falls similar with the principle held in R versus Raju. And Justice Spencer Wilkinson held that in this country, such evidence of similar acts is often admissible under Section 15 of the Evidence Ordinance, though certain types of evidence of similar offences or acts may be admissible under Section 14 and 11. Generally speaking, the evidence of similar facts may be relevant for the following purpose, though this list may not be exhaustive. And one of it is to prove the identity. And in the Australian case of Rao versus Gale versus and R versus Duckworth, The Australian also follows the principle of similar evidence, and in Australian, it is known as the coincident evidence. And the court held that in applying the similar fact evidence, the process of reasoning from which that inference would be drawn is, first, two or more events occur, and second, there were similarities in those events, or there were similarities in the circumstances in which those events occur, or there were similarities in both the events and the circumstances in which they occur. And thirdly, having regard to those similarities, it is impossible that two events occur coincidentally, and therefore, the person in question did a particular act or had a particular state of mind. And the application of the similar fact evidence can be seen in the case of Terry versus the Queen. In the current case, the evidence are the death of the appellant's first husband in 1961 due to acute arsenic poisoning in circumstances where she did collect life insurance money upon his death. And second is the death of appellant's brother in 1962 by acute arsenic poisoning in their mother's house in circumstances where she was the last person to see him alive and the first person to see him dead, and had days earlier placed weed killer on the shelf in that house. And thirdly is the death of the appellant's second husband from an for an overdose of barbiturates in 1970, and in the circumstances where she did collect life insurance upon his death. And these three instances shows that the appellant collect life insurance from the three-person death. And Chief Justice Gibbs stated that where a number of poisoning have occurred and the victim have all been associated with the accused person, the evidence of the other poisonings may be admissible to support the inference that the accused was responsible for the death in issue, because it would be contrary to an ordinary experience that a series of poisoning caused by accident or suicide would occur by coincidence in the circle of persons with whom the accused was associated. And next is the R versus Smith, which is also known as the brides in the bath case. And Lord Mohun in this case held that no reasonable man could believe it possible that Smith had successively married three women, persuaded them to make wills in his favor, bought three suitable baths, placed them in rooms which could not be locked, taken each wife to a doctor, and suggested to him that she suffered from epileptic fits, and had then been so unlucky that each of the three had some kind of fit in the bath and been drawn. And when applying the similar fact evidence, the Azan case held that the court must also balance the probative and prejudicial effect in admitting those evidence under Section 14 and 15. And the court held that it is an implied condition under both of these sections. And by applying the above, the aforesaid principle, in the current case, there were multiple identical facts listed down. The first is all the victims are female. Second is all the deaths occur in Georgetown between 2 p.m. and 4 p.m. And third is all the victims were tied up, raped, and then strangled. And fourthly, all the victims were alone at home. And fifth, Noodle was seen entering those houses where the victims died, but all these houses did not have an electrical fault. And lastly is when all the deaths occur, Noodles was on a day off. And from the facts listed down, we can see that there is a same killing pattern and the death occur in the same timing, in the same location. And similarly, Noodles was seen to have visited those houses with no valid reason. And through the entering of those houses, it provides Noodle with the knowledge of the structure of the house and also when the deceased will be alone at home. And also, coincidentally, Noodles was taking day off when all the victims were killed. And where all the killings have occurred, all associated with Noodles, it would be unreasonable to believe that it is a mere coincidence that all the persons associated with Noodles will die in a similar in a similar style of murder, in a similar pattern of being murdered. And this coincidence happens not only once, but fourth. And so it can be concluded that Noodles is the one who is highly probable. Noodle is highly probable to be the one who killed all the 4 victims, including Mrs. Tua. So we submit that the probative value of this evidence is so high that non-resident men who believe that the deaths that occur during Noodle's day off are just a mere coincidence or accident, and it clearly overrides the prejudicial effect that may cause Noodle. And this is the concluding application of Section 15. And I shall pass the floor to the next presenter.
Now I will proceed with the second issue, which is whether Section 14 is applicable to the current case. Section 14 and Section 15 of Evidence Act are related in some way. Section 14 and Section 50 are usually invoked when it comes to similar facts evidence. Section 14 facts read as facts showing the existence of any state of mind, such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill towards any particular person, or showing the existence of any state of body or bodily feelings, are relevant when the existence of any such state of mind or bodily feeling is in issue or relevant. A plain reading of the Section 14 illustrates that it is intended for facts establishing the existence of the accused relevant state of mind, or in other words, the intention to commit the offence. The illustration shown in Section 14 has demonstrated that the said section can be applicable to show intention, to show negligence, to show intoxication, and to show knowledge. All of this has the same purpose, which is to find out of the state of mind of the accused when the crime happened. Next slide. So in the case of public prosecutor against Teo Aini and another, the court explained how this Section 14 works. The accused was charged with possessing infringing copies, and the prosecution introduced evidence of similar facts to establish the evidence of mental state known as knowledge. The court said that in order to prove that a person had a state of mind, the state of mind must not be general. It must be specific to the matter at hand, and this requirement is very high. In another case, which is Lee Wee Tiang Anthony against the public prosecutor, the accused repeated a statement about hiring someone to murder his wife, demonstrated in hatred for her. This evidence was accepted due to its relevance to the charge of murder instigation, as Section 14 imposed a requirement of the particularity of state of mind. The application of this issue will proceed with the next presenter.
Thank you. So in finding out whether Section 14 can be applied in the present case, it is pertinent to determine the prosecutor's intention to admit the similar fact evidence that happened through the repeated similar occurrence. This is because Noodle was charged for the murder of Mrs. Tua, in which Mrs. Tua has been tied up, raped, and strangled. The modus operandi in Mrs. Tua murder case is very similar to the death of one other old widow, and as well as 2 other young girls, all of whom is very similar to the death of Mrs. Tua. So all the deaths also occurred in Georgetown, Penang, and all the victims were all alone at the time of the murder, as explained in the first issue. So all the case and principle above indicates that Section 14 is used to show the mens rea of the accused when the actus reus is there. However, in the present case, no actus reus has been proven, which is Noodle has not been proven to be the one causing the death of Mrs. Tua. The purpose of the prosecutor in adducing the similar fact evidence in the present case of the other victim in Noodle's trials is to prove the identity of the accused in this case, and to negate the possible defense that such a similarity is just a mere coincidence and accident. As such, there provide no room for Section 14 to be applied in this case. The case would be different if Noodle was caught to have attempt to kill or injure Mrs. Tua before, or is proved to have some ill will towards Mrs. Tua before. Only in that circumstances, Section 14 may be applicable. In conclusion, Section 14 is not fitting to be applicable to recurring case because the purpose of Section 14 is not parallel with the basis of admitting the similar fact evidence in the present case. Hence, Section 14 is not relevant to the present case. So that's all for the second issue.
Moving on for issue number 3. But first of all, I would like to apologize for not able to turn on my camera because of my internet connection just now. So the third issue is whether the similar fact evidence may be admitted under Section 11B of Evidence Act. The general rule is that evidence of similar fact may be admissible under Section 11B of Evidence Act. However, there are a few situations where courts are reluctant to admit similar fact evidence under Section 11B. Section 11B is incapable of accommodating evidence of similar fact because the evidence must be similar to the facts in issue but unconnected to it. The connection between facts to be proved and facts sought to be given must be so immediate to render it highly probable. So in other words, Section 11B does not admit facts that are not reasonably conclusive and have no connection with the main facts. Next slide. Application of Section 11B are also limited in its operation. For instance, under Section 54 of Evidence Act, it will exclude the evidence of one crime to provide evidence of another unconnected crime, even though it is connected with each other. Furthermore, similar fact evidence also cannot be made relevant when it has been declared relevant by Section 14 and Section 15 of Evidence Act. This is because Section 11 is merely a residuary section which deals with the relevancy of facts. And according to Augustine Paul and Jeffrey Pinsler, Section 11B is incapable of accommodating the evidence of similar facts because the wording in the section was intended as a residuary section. So reference can be made in the case of Public Prosecutor and Jazri Johari, where in this case, the court does not allow the prosecution to rely on Section 11 of Evidence Act to adduce evidence of the other drugs found in the car because the evidence of one crime not reduced to a legal certainty as in a conviction cannot provide evidence of another unconnected crime. In this case also, the court held that this section cannot be applied to facts which have already been made relevant by other provisions of the Act, such as similar fact evidence which has been declared relevant by Section 14 and Section 15 of Evidence Act. So applying the current situation, the applicability to admit similar fact evidence under Section 11B may not be relevant in nodal situation. This is because even with all the similarities in Mrs. Tua case with other murder cases, the prosecutor may not be able to admit the similar evidence to adduce Nurul as the murderer because there is no evidence that shows Nurul actually did murder the other victims in the previous cases. Other than that, Section 11B may not be applicable to admit similar facts evidence which have already been made relevant by Section 15 of Evidence Act. Thus, Section 11B cannot be said to have the effect to reinforce the law of relevancy by rendering relevant which has already been declared relevant. In conclusion, Section 11B may not be applicable in this situation because by rendering the evidence by virtue of this section may cause it to be redundant with the Section 15 of the Evidence Act.
Okay, moving on to the last issue, as in the fourth issue, whether the defense of alibi pleaded by Nurul can be admissible to the court pursuant to the Section 11 of the Evidence Act. For the definition of the alibi, evidence or defense it is a evidence or defense which shows that the defendant was at the other place, as in not at the crime scene when the crime occurred in the criminal proceeding. So this can be referred to the latest case T. Hock Keong against public prosecutor, where the accused raised the defense of alibi. However, there is no witness to testify him. The court held that the defense failed since the lack of evidence in support of the alibi affirmatively placed the appellant at the crime scene. And in another case, Duis Hakim and others against public prosecutor, where it stated that the defense of alibi must preclude the possibility that the accused could have been physically present at the place of the crime or its vicinity or about the time of its commissions. So here's the applicable law related to this issue. where we would like to highlight about the section 11A, where it stated that the facts that are not otherwise relevant become relevant when it is inconsistent with any fact in issue or relevant issue. So in this section, the word inconsistency indicates that the physical impossibility of the fact that was sought to be admitted as relevant to coexist with the issue. So for example, the introduction of the defense of alibis show that the accused was alleged to have committed a crime where and also where he was at a different place. So in the case of that defense, if the element of the time of the crime is fixed and the accused is shown to have been at some other place at that time, the two facts are mutually inconsistent. And the proof of the charge cannot be established. So the proof of the defense of alibi will enable the court to decide one way or the other regarding the truth of the charge. In applying the defense of alibi, it also comes to the section 103 of the Evidence Act and also of section 402 of CPC, where section 103 it lay down about the burden of proof lies on the accused who pleaded the defense of alibi and the section 402 it stated that the accused has to comply with the two procedures, where firstly the must send a notice to public prosecutor and secondly the details of the witness. So applying to this case, the fact that witness claimed to have seen Noodle enter various houses to repair some electrical faults is relevant and it may be accessible to the court. However, when Noodle stated that he was actually at home, may also be admissible to the court as this fact is inconsistent with facts claimed by the witness. Also, the fact that Noodle was at a different place when Mr. Tuang was murdered indicate that he cannot be at two different places at one time, which means that Noodle cannot be the murderer as alleged by the prosecutor. Thus, the fact that Noodle was at his house on the day of Mr. Tuang died are relevant under section 11A. Besides, Noodle can prove that he was at different place when the murder of Mrs. Tuang, as his wife would like to testify his alibi. And the burden of proof, the claim lies on Noodle as according to section 103 of Evidence Act and also section 402 of the CPC. In conclusions, therefore Noodle may raise the defense of alibi according to section 11A despite the inconsistency with the fact issue when the witness saw him enter their houses, and Noodle's statements may also be relevant and it may be admissible to the court provided that Noodle had complied with the requirement to plead the defense of alibi pursuant to section 103 of Evidence Act and together with section 402 of CPC. So that's all from us. Thank you.